Hello, I'm Van Smith, managing partner here at Smith Strong, and today I'd like to talk to you about preparing for a protective order hearing in Virginia. Protective orders come on us fast. There's an incident that occurs, usually at the outset or before a divorce matter or a custody matter. Emotions are high, and all of a sudden now police are summoned, or there's an incident where we go to the magistrate and swear out facts or pleadings that necessitate an emergency protective order or EPO to be issued. That's issued, but then within a matter of days, a PPO, a permanent protective order hearing, is needed. And so you're having to scramble to find the right attorney, meet with that attorney, get prepared, and appear for a protective order hearing in Virginia in a matter of hours and days. And so it's very important to make sure you're fully prepared for that meeting that you may only have 1 to 3 days to get ready for. I want to lay out a few things that I would want to tell a family member if they were in that situation in preparation for meeting with us. Protective orders come on fast, but there's usually a chain of events that occurred immediately before, during, and after that incident that we need to capture and have an accurate, itemized chronology of exactly what occurred, so we're prepared for court. If we get the facts wrong, if we get the facts out of order, if we forget key details to bring them up, it can sink the case on either side. And so we do not want to lose or deteriorate credibility by not appearing to have full command of the facts in that moment. I think a key to persuasion in court is being in command of the facts, being the source, the resource in court for having complete understanding of the case, and being a sincere, integrity-filled person to give those facts to a court that's eager to hear them, but quite frankly, overwhelmed by the number of cases on their dockets. And so they're looking for truth, they're looking for trust, and they're looking for a command of the facts that they can rely on because they want to get this right, but they also don't have as much energy or time as they would like, always, to get these matters heard and facilitated. And so, very important in preparation of a protective order hearing and in meeting with your attorney to have an itemized chronology of exactly what occurred, minute by minute, even at some point, seconds by seconds. It'll be also important to capture all the photographic evidence of the incident or injury or situation. It's going to be important to preserve text messages and photographs and maybe even some exhibits of items that were thrown or struck or hit. Bringing those with you to the consultation with the attorney is fine as long as they're not loaded firearms or firearms in particular. But if there are pill bottles, or if there was a blunt force object like a hammer, or if there are text messages, or if there's photographic evidence, those items that don't present an obvious danger to the office setting should be brought. If there's any question on that in preparation for your protective order hearing, give us a call, and our trained staff can walk you through what is helpful to bring to that first consultation. But key, number one, an itemized chronology. Number two, the evidence that supports that chronology. And number three, any other factor that could be helpful. And those vary by the type of incident. I'll give you an example. I remember I had a protective order that went till 9 or 10 at night in Henrico County a few years back. And the husband, who was a doctor, had a cup of water and threw it in his wife's face and said, "That's what acid is going to feel like on your face soon." And because of the history of physical abuse and because of the unique dynamic of their relationship, she knew that this was a serious charge. And so that cup was brought to the consultation. We have downstairs in our office, as a gift from the client who was pleased with her service by our firm, a concrete mushroom, a garden ornamental mushroom that was thrown through the window at her to harm her. And after a successful protective order hearing, she gave us the garden concrete mushroom, and it still remains in one of our conference rooms here. And so key preparation, chronology, and capturing of evidence, keeping that organized. This is an unbelievably emotional time for you. It's a disruption of your family, of your household, perhaps of your children, of your own life. But the stakes are very high to get this right. These hearings are usually very short, and we have to be prepared, punchy, and ready. And so I hope this video helps you form the understanding of what you need. It's okay to be emotional in those consultations, but also be ready with the itemized facts and evidence to help win your case. If you have been wrongfully accused, and now you're in need of defense against a protective order, we know the stakes could never be higher. Rightly or wrongly, Virginia now will prevent you from being able to own or possess a firearm if protective orders are established. We have physician clients and doctor clients who were not given board certification or promotions that have permanent and long-term consequences over their career if protective orders are established through frivolous facts. And so we must take this seriously on either side of the transaction that you're on, whether the victim or the alleged perpetrator. We have to get this right. We look forward to meeting with you, bringing order to the chaos of this situation, and we know we don't have a lot of time to prepare. Thank you for your time today.